8301 of 2023. My Lord, I'm sorry, I have committed the same mistake as some of the earlier counsels. जो extracts और foreign judgments थे मैंने अभी दिए हैं.
8301.
I apologize, sir.
अब प्रेसिडेंट बन गया है.
Sir, I'll keep a mind of it. In future, sir, I'll be careful of it.
ये चला कर 8301 अगर निकाल लें.
There should be a booklet in front of your lordships and the CMA. That is all I will be relying on. May I?
जी.
Lord, first of all, there's a question of maintainability. At least as far as I am concerned, sir, I'll not be raising that issue. And for the reason that the last time I was on my legs before an 8-member bench, my argument was that due to the public importance and constitutional import of this case, it should be heard by a full court.
And आगे बढ़ें.
Sir, now on merit, sir, there are 3 questions to my mind. Firstly, can Parliament legislate regarding practice and procedure of Supreme Court and in any case override provisions of the Supreme Court rules 1980? Number 2, can Parliament create a right of intra-court appeal against orders under 184(3)? And number 3, whether even assuming the above can be done, do the provisions of the 2023 Act otherwise somehow conflict with any provision of the Constitution? Now, before taking your lordships to the relevant entries and Article 191 and so on and so forth, I'd like to make some submissions, sir, regarding the overall conceptual framework within which I view this issue, and also the background and necessity of the legislation, especially since the petitioners and the counsel for the PTI have directly attributed a mala fide political intent behind this act, arising from a desire to subjugate the independence of the judiciary. Now, I agree with the petitioners that issues relating to independence of judiciary do directly engage fundamental rights guaranteed under 9, 10, 10A of the Constitution. But there is a crucial difference between all the previous cases decided by this court, Mehram Ali, Rawalpindi District Bar, Liaquat Hussain, Al-Jihad, etc., and this particular case. All the previous judgments of this court basically deal with external threats to the independence of judiciary. My humble submission is that this case primarily relates to internal threats to the independence of judiciary. It is what Justice Asif Saeed Khosa, as his lordship then was, referred to as the final frontier of judicial independence. My submission will be that the constitutional guarantee of independence of judiciary covers both external independence and internal independence. Now, I'd like to start, sir, by reading 2 short passages from the article of Justice Khosa. He wrote this when he was a judge of the Lahore High Court. So this is page 1 of the booklet. And if your lordship will see page 4, I'll read a couple of passages from there, and page 6. So the second para, page 4. Now I come to the 4th stage, which I call the final frontier. in my capacity as a lawyer, I had written and spoken about independence of judiciary on several occasions, but now my perspective and angle are slightly different. Having spent a good number of years on the bench, I have seen the system from within, and thus I know and understand a few things which an outsider may not be in position to appreciate. In this background, I intend to share some aspects of independence of judiciary which are generally overlooked. But these aspects are so important that without attending to them, the whole superstructure of independence of judiciary remains incomplete, and if I may say so, shallow and superficial. I'll skip a para, sir, to save time, then the para after that. It is some of these areas and aspects, often ignored and overlooked, which I intend to highlight. The earlier stages I have mentioned are essentially relevant to threats to independence of judiciary from outside the judiciary. But the final frontier envisioned by me is the stage where independence of judiciary is achieved through a successful passage of the earlier stages, is to be protected from the threats originating from within the judiciary itself. Three areas appear to me of particular importance in this context: independence from oneself, independence from judiciary, and independence from justice. Now, if your lordship will turn the page to page 6. In the first part of the final frontier, he deals with how judges have to rise above their own personal inclinations, ideological inclinations, biases, so forth. And then the second part is discussed here. The second aspect of the final frontier is the independence of an individual judge from the undue pressures of his peers and from unnecessary or unwarranted controls of his institution. There is no doubt that in his capacity as a judge, a person performing judicial functions is necessarily a part of his institution, i.e. the judiciary, and ordinarily his functioning is to be in line with the overall policy and scheme of the institution. However, the problem comes when the institution's independence is itself under cloud because of extraneous factors, and an individual judge starts abdicating his decision-making before the dictates of the institution, or conversely, when the institution starts excluding an individual judge from decision-making in sensitive matters because that judge is not likely to toe the line of the institution. Both these factors, which may be unthinkable in the civilized world, are unfortunately real possibilities in some other parts of the world and completely undermine the notions of independence of judiciary. Apart from the above, concentration of powers in the hands of the head of a judicial institution regarding constitution of benches, allocation and distribution of cases amongst benches, attaching priority to different kinds of cases, and geographic transfer of judges is an issue which has raised eyebrows in the past and can also resurface in the future. A possible misuse of such powers by the head of a judicial institution can effectively render the independence of an individual judge to be of no practical utility or benefits to the citizens at large. Such a threat to independence of judiciary has its origins within the judiciary itself, and any degree of independence of judiciary painstakingly achieved through all the other stages mentioned above can effectively be neutralized through machinations from within the judiciary itself. In this context, I feel that independence from judiciary in the above mentioned areas may be a sine qua non for reaching the final frontier of independence of judiciary. Now, of course, the author of this article eventually adorned the office of the Chief Justice of Pakistan, but nonetheless, for whatsoever reasons, no structural change could be brought about to achieve this final frontier of judicial independence. Now, this concern about the untrammeled powers, the untrammeled discretion of Chief Justices is not unique to Justice Khosa. Another future Chief Justice has also...
Mr. Salahuddin, it is a person-specific argument which you are raising before us?
Not at all, sir. What I am saying is that this concern has been raised by multiple of your lordships.
The issue before us, to come to that.
Yes. The issue that I am coming to, sir, is that there have been multiple concerns expressed by the judiciary itself about the concentration of powers in the office of the Chief Justice and the potential for abuse of those powers and the perception that it creates in the general public. Now, those are exactly the issues when Parliament is being accused of acting with...
The matter relates to the institution.
Yes, sir.
Please, we are sitting to hear you.
Let's go for let's look at the law. Your point is taken. You feel that there are voices coming from the bench. Fine, point taken.
Mr. Salahuddin, whatever you are saying assumes competence. That's the one of the key points over there.
I will come to both those.
All of this may be right, all of this may be wrong, some of it may be right, some of it may be wrong. Tell us about competence.
I will address the issue of competence if your lordships will allow me.
ये तो चले किसी का अपना view है होगा.
Sir, bilkul. I'll just cite, not read from them, but I will cite the different judgments in which, at least I think, if I'm counting correctly, 10 members of this present bench have raised concerns about the concentration of powers in the office of the Chief Justice. And my submission would be that in itself dispels any argument of malafide.
Does that in itself confer legislative
No, sir,
competence
it does
on
not. It
Parliament?
does not, and I will deal with those independently. I'm just completing this, sir.
Kindly tell us what you say about who is Parliament the master of the roster?
Yes,
as a matter of principle.
I will come to that, sir. I will come to that,
किसी
sir.
की कोई view है, किसी की क्या view है?
Yes, I will come to that. I just want to quickly cite those judgments, sir. PLD 2019, Supreme Court, page 183.
183.
Yes, sir. PLD 2021.
What proposition is this?
Sir, these are all judgments and dissenting notes and additional notes in which different judges of this court have on various occasions raised.
I think you should be a bit careful, with all due respect. I don't want to stop you from making your submissions, but you're treading on relatively thin ice here, in the sense that if you're quoting a retired judge, that's one thing. But if you're quoting sitting judges in this particular context, before a full court, when the very competency of Parliament is under challenge, I think it's better for you to just focus on. I hope you've understood what I'm saying. I don't want to say anything
I'm
further.
not, and that's why I'm just placing
Please don't.
I would like to hear what you're
Views have
saying.
been expressed, they have been
I
expressed.
would like to
placing
hear what
those
you're saying.
judgments before your lordships. I'm not
citation
any
बताइए,
any extraneous material. I'm not.
Yes, Salahuddin.
Can you please cite them?
Citation बताइए,
Sir,
citation.
PLD 2019, Supreme Court 183. Then PLD 2021, Supreme Court 446. There is a dissenting note in that.
कोई relevant pages आप नहीं बता रहे हमें. Relevant pages.
Sir, I'll dig them out then, sir. PLD 2021, Supreme Court 446 में, sir, it is...
इसका टाइटल केस का क्या है?
Sir, ये PM's discretionary fund है. The earlier one is...
चलो लिख के दे देंगे pages.
जी, मैं दे देता हूँ,
आप
sir.
citation
जी,
से.
मैं दे देता हूँ, sir. Then there is PLD 2023, Supreme Court, page 306. There is PLD 2022, Supreme Court, page 3006.
2023 Supreme Court.
PLD 2022, Supreme Court, 306.
23 का भी आपने बताया, ये 22 का भी same page.
जी, नहीं, PLD 2023, Supreme Court, 306, and PLD 2022, Supreme Court 306.
Both have the same page.
And उसमें this second one, sir, जो 2022 का है, that is Suomoto case number 4 of 2021. And in
चलिए वो
that,
देख लेंगे ना. Let's just
I
cite
rely
them.
on paras 53 and 56.
53.
अभी citations ही दे दें.
That's it.
And sir, there is SMC number 1 of 2023. There are 3 separate notes in that.
Reported or not reported?
Also not reported as yet.
SMC number?
1 of 2023.
ठीक.
And SMC number 4 of 2022. Now, in addition to that, sir, the bar councils and bar associations have obviously been passing resolutions on this issue for almost
All
a
due
decade.
respect again to the bars
Yes.
and council.
Main question.
What does that have to do with
My
competence?
lord, there is.
I mean, are we supposed to be swayed by, with all due respect to what, those are extra judicial
Not at all.
statements.
Not at all.
Kindly
Your
talk the
lordship-
language of the law.
Your lordship will appreciate.
See,
That's-
कानून की बात कीजिए, ये तो नहीं कि
Salahuddin, there are only 2 questions involved here.
Ji, sir.
One is who is competent, question of competency. And 2, if we come to the conclusion that yes, there is competence, then you have to convince us that the law as framed is not in conflict with any provision of the Constitution. If you would kindly address these questions, I mean, most of your case would be
My lord,
encompassed in that.
I'm grateful to your lordships. What the main challenge by the petitioners has been on 2 grounds. One, that it infringes, the legislation infringes the independence of judiciary. That is one completely separate issue. And the second is that it is beyond the legislative competence of Parliament. Now, in the legislative competence issue, obviously, whether the law is an excellent law or a terrible law is irrelevant. I will gratefully adopt your lordship's formulation on that. But as far as the challenge on the basis of independence of judiciary is concerned, the merits and substance of the law and its background is very relevant. That is why I'm briefly, I'll come to the legislative competence too. Sir, if your lordships will see that I'm not going to go through the resolutions or anything, but they're at page 171 to 185 of that booklet.
But
And if your lordship,
one thing, I've seen judgments of this court which have cited news reports for relying on various things, and consequences have flowed from those news reports. So I, for one, do respect what the highest bodies of lawyers have to say, whether it be the Pakistan Bar Council or the Supreme Court Bar Association, most ably represented by Mr. Abid Zubairi. So if you want to file those, I mean, I would place greater credence on them than on newspaper reports which have been taken note of and judgments passed by relying thereon. So if we keep talking about this chariot perpetually ad nauseum, the 2 wheels of the chariot, now let us see this chariot work.
it is, in my humble submission, is
But I think
that they are relevant.
I think competence of a law has never been, as far as I
I certainly want to hear a person's point of view.
is decided on the basis of newspaper reports. Those are other contexts.
Yes, legislative competence is a separate issue. I'm dealing right now with the independence of
Right now
the
you-
seeming
No,
infringement.
but independence of the judiciary itself is, if it is violated, that then the law is incompetent. Competence is not just legislative competence. Competence is also competence vis-a-vis other provisions of the Constitution.
My lord,
And what the people perceive independence to be, and more so than the people, those dealing with the law, which is the legal community. So I definitely want to see the perception of independence. I mean, it may be very independent, but people may think it otherwise, and vice versa. It may not be independent, and people may think it very independent. So yes, you don't have to spend a lot of time on it. If you can just refer to them or give it to us.
They are at pages 171 to 185. And they are resolutions that what I was able to discover were only dating back till 2018. But I understand PBC has filed something going back to 10 years ago. But there is just one aspect of those resolutions that I would ask your lordships to consider. And that goes to some of the questions that have been raised. If your lordship sees that initially in all those resolutions, the request was for this court to amend the Supreme Court rules to regulate the suo motu power and to regulate the master of roster power. That was the demand for the major period. Eventually, there has been a change in the tone and direction in the last 2 or 3 years, which has then now, in the more recent resolutions, asked for Parliament itself to directly act under 175 and 191. And presumably, the change in direction was because there was no effective response from this court on its administrative side. I'll move on, sir. Now, Justice Hilali had asked 2 pertinent questions, and Mr. Zahid Ibrahim had also pointed out the need to look outside. And those 2 questions was, one, if the CJ's power to form benches and assign cases was taken away, what would be left of the CJ's office? And secondly, how the formation of benches and fixation of cases is dealt with in other countries. Now, the answer to that first question is that there are certain specific powers and rights of the Chief Justice that are enshrined in the Constitution itself. There are about 9 that I can think of. I'm not going to go through them all, but they are there in my concise statement. Apart from the ceremonial powers, there are 9 concrete powers. The power to make benches and assign cases is not a constitutional power at all. It is not mentioned anywhere in the Constitution. In 1935, in the Government of India Act, it was indeed a constitutional power of the Chief Justice. In the 1956 power, there was a direct provision in the 1935 Act. In 1956, that power was moved to the 3rd schedule of the 56th Constitution and made subject to rules, and then by virtue of Article 177 made subject to Act of Parliament.
This was
After
1962?
1956.
56.
3rd schedule में थी power that the Chief Justice may subject to rules, form benches, etc. And that was in turn subject to Article 177.
What about the power under the Government of India Act 1935, which was the first constitution of Pakistan from 1947 through to 1956? What was how was the power there framed?
In the 1935? I'll just read the exact.
What is the section?
Ji, sir.
Read section 214.
It is 2143. Subject to the provisions of any rules of court, the Chief Justice of India shall determine what judges are to constitute any division of the court.
Now kindly read subsection.
And what judges are to sit for any purpose.
Power of the roster.
Ji, sir?
The power of the roster.
Yes, it was there.
Now actually, the power of the roster goes much further back in time. Have you seen the Indian High Courts Act of 1861?
No, sir, I have not.
Let me tell you where this power comes from and how it ends up in the judicial case law. You see, after the British took direct rule of India in 1858, one of the first laws that was made in 1861 was in relation to the power to issue letters patent to create high courts. Madras, Calcutta,
Yes.
Bombay and all that. So this is something that goes back to the very beginning of British rule in India. Now this provision, this Act of 1861, also had something to say in relation to that. Let me read out to you section 14 of this Act, 1861. Because at that time there were only high courts, right? Federal court comes in 1935. The Chief Justice of each court shall from time to time determine what judge in each case shall sit alone and what judges of the court, whether with or without the Chief Justice, shall constitute the several division courts as aforesaid. So the Chief Justice as the master of the roster is a power that goes back to the very beginning of British rule and whatever follows thereafter. This position continues for several decades until we reach 1935. In between we have the Government of India Act 1915. वो आपने देखा है? नहीं. उसमें भी section 108 था, which was in exactly these terms. ठीक है? अब आपका आ गया 1935 का Government of India Act, where you just read out for us subsection 3, right? Subject to rules made. But the rule making power under subsection 1, legislature had no interference with that.
Yes, sir.
Then we have the
But the Governor General did. It was with the approval of the Governor.
Approval.
Yes.
He couldn't make them, he could only approve.
Yes, but the approval in his discretion.
As originally contained.
My lord.
Now we come to the 56th Constitution, uske provisions aapne hame bataye hain. Then we come to the 1962 Constitution, where the article takes the shape that it now has. But the 62 Constitution, as I said when Mr. Ibrahim was arguing, in the third schedule, it had a specific legislative entry for Supreme Court.
Yes.
Interim Constitution reverts structurally to the position of
Government in India.
1973 Constitution does that. Now it seems to me that if you look at the grand sweep of constitutional history, starting from 1861 onwards, the 56th Constitution, which is perhaps the high water mark of legislative interference with matters relating to the power of the roster, out of those centuries-long period, this is a very narrow window, hardly a few years, right? This expanse, which I think is about 150, 160 years, then culminates in the judicial case law, the case law that was referred to by Mr. Bindari, that it is the Chief Justice who is the master of the roster. Now, this is not something that the judges were creating out of thin air. This was a rule going back centuries old. It was deeply etched in the law. Now, the question to you is this. Mr. Bindari said that there is a constitutional convention that the Chief Justice is the master of the roster. If you look at the expanse of constitutional history, if you look at it in historical perspective, it is at least arguable that there is this convention, or at least a constitutional rule of ancient standing, right? The question to you is this. In our constitutional law, conventions are legally enforceable. So even if this rule is only now embedded in case law, can it not be said that it is a constitutional convention, and therefore sections 3 and 4, setting up the committee and so on, they are ultra vires, even though it's not there in the express text of the Constitution. But conventions, by definition, have to look at the much broader perspective of constitutional history, right? Looking at it from that perspective, perhaps at least it's arguable. I'm not saying it's at least arguable that what Mr. Bindari was saying was correct, that there is a constitutional convention, and therefore it's beyond what Parliament has done or sought to do in sections 3 and 4. What would you say to that?
My lord, respectfully, I take a completely converse view of the constitutional history. To me, it seems that under and prior to the 1935 Government of India Act, but under the Government of India Act, there's an express provision in the Constitution itself regarding the role of the Chief Justice. In the 1956 Constitution, that is diluted somewhat, that power is taken away to a schedule, schedule is made subject to rules, rules are made subject to the Act. 62 onwards, the very mention of the Chief Justice's power as master of the roster is removed from the Constitution. So to me, it speaks of a constitutional intent to reduce the role of the Chief Justice and enhance the role of the Honorable Supreme Court.
But Mr. Salahuddin, the point is it is removed from the constitutional text. But the question I'm putting to you is the submission made by Mr. Bindari that it is a constitutional convention. Conventions by definition are not in the text. And if it is a constitutional convention, which is recognized in that Hamid Sarfaraz case, PLD 1979 Supreme Court and other case law, that constitutional convention does not emerge suddenly out of nowhere. That constitutional convention has the backing of centuries old constitutional practices and even matters which are textually to be found in the relevant statutes. If there is this convention, and conventions are recognized under our constitutional law, would that not be your sections not be in violation of
My lord, my understanding, I'll just give a brief answer and then move on. My understanding is that constitutional conventions are subordinate to actual constitutional intent as expressed by words. Now, if the legislators remove a particular constitutional power, one cannot just disregard that removal. That removal must have a purpose. And my submission is that the purpose of the omission of the Master of Rolls power from the Constitution is to empower the court in favor of the Chief Justice. I'll move on, sir. Now, well, the second question of your ladyship was...
Mr. Salahuddin, Chief Justice is holding a constitutional post.
Yes.
And the powers exercised by him are not constitutional.
My lord, there are some powers that are constitutional, 9 in fact, which are mentioned in Article 10(4), 146, 152, 159.
Where it is differentiated that he cannot exercise the constitutional authority.
My lord, because the power as master of roster comes to him by virtue of the Supreme Court rules. It does not say in the Constitution.
In present circumstances, those powers are exercised in pursuance of Article 191 of the Constitution.
No, sir. Yes, indirectly. Yes, from 191 and then the Supreme Court rules and then.
Those are framed under Article 191.
चलिए आप ये जो present scheme of constitution है ना, you just explain the legislative competence on the present constitution.
जी.
क्या आपका इसके अंदर है?
Sir, I'll just come to sir. एक मैं quickly complete कर दूं sir, because there was a question about what is happening elsewhere, and I think that will inform the reading of our constitution as well. Sir, एक इंडिया का मिसाल दिया था भंडारी साहब ने शांति भूषण की जजमेंट साइट की थी, where the Indian Supreme Court has held that the Chief Justice has absolute prerogative as master of the roster. But the background of that judgment, and I think this is perhaps the article that your lordship had referred to, that is at page 10 of the booklet. And the background is very instructive, sir. What happened was that in January 2018, 4 senior-most judges of the Supreme Court of India held a press conference against their own Chief Justice. And they said that cases having far-reaching consequences for the nation and the institutions have been assigned by the Chief Justice of this court selectively to benches of his own preference. Now, just a month before this press conference, there was a case which is reported at 2018 1 SCC 196. It's page 124 of the booklet, in which the powers of the Chief Justice, the case fixation powers of the Chief Justice were challenged. The Honorable Chief Justice of India formed a bench, presided over it, and dismissed that petition. Then after the press conference in April 2018, Chief Justice Deepak Mishra again headed a 3-member bench, which heard Ashok Pandey's case against the Master of Rolls powers and seeking an amendment to the Supreme Court rules, and he dismissed the same. That is at page 128 of the booklet. And only thereafter, in July 2018, Shanti Bhushan's case was decided following the earlier 2 precedents. Now, interestingly, in India, one of the Chief Justices who held the press conference one of the judges who held the press conference against the Chief Justice, Justice Raman Gogoi, he himself became Chief
I was
Justice.
wondering when you would come to that.
That's the most interesting part.
And when he became...
Mr. Salahuddin Ahmed, we became independent in 1947. We can learn from other countries by all means. But whilst we refer to Indian judgments quite generally in all our judgments, I've never seen it reciprocated in India. Have you ever come across an Indian Supreme Court judgment or any High Court judgment which has ever referred to a judgment of Pakistan?
But I think there are some very early ones, but not of late at least.
I'm just saying this perpetual fascination with what happens across the border. Why can't we just stick to our constitution, their constitution? We've seen what they've done with their constitution. I don't know how they're going to decide Article 370. Let's see the independence of the judiciary there. Let's not put that as the benchmark for the best what happens in the world. Let's stick to our own thing. They are welcome to theirs. Let us be guided by our own lights. I mean, we're not looking to Islam. I mean, that is brushed under the carpet. We're looking to India, we're looking to the US, and when anything Islamic comes up, the constitution starts with the word. Islam mandates the right of appeal. Even the Almighty does not condemn without having heard. And why we are not going by our traditions at all. I mean, just everything Indian, everything. Then they don't even reciprocate. I mean, fine, they don't need to. That's up to them. But why are we so beholden always?
I'm saying the opposite, sir, in fact. I'm saying that one should also learn from the mistakes of our neighboring jurisdictions, not just from their judgments. And that is why I was pointing out, sir, that Justice Raman Gogoi, when he became Chief Justice, the bar went to him and said that now reform the powers of the Chief Justice. He refused, and then there was a sexual harassment petition against him, and he fixed it before himself and dismissed that. So the Indian citations, I agree with your lordship, are to be taken with a pinch of salt. Now, a similar situation, sir, arose in Nepal. And I do think, sir, that when we are looking at foreign examples, perhaps relying upon US and UK jurisdictions itself might not be so apt for our socio-political, economic realities. We should look at countries closer to us.
Before you move
So we are taking a poll of the countries in the world.
Not at all, sir.
I mean, 200 countries do this, we must do it, or vice versa.
It is a reflection of the same problem that has arisen elsewhere.
But to your knowledge, I mean, before you move on to Nepal, in India, up to now, has Parliament then stepped into the breach?
No, sir.
No. Thank you.
Mr. Salahuddin, whether the constitutional convention...
Does that mean our Parliament is more vigilant?
Yes.
You just say no, I mean, you don't expand anything further.
My lord, I agree that our Parliament has acted because there was a vacuum.
I'm still waiting in all of this to get to
the constitutional competence. Yes, sir. I'm coming. I'll be there, sir, very shortly.
Mr. Salahuddin,
Nepal and Bangladesh and
very shortly, sir. Just two more submissions on this regard and I'll move on.
Don't forget Maldives. Very important.
Kindly, the Constitution Convention, does they have the status of Constitution? Can they be changed in accordance to the coming situations? Or if it can be changed, who can change it? Whether convention is fixed, it cannot be changed.
My lord, that is exactly the difficulty, as I understand it, of constitutional conventions. Because if you have a position that the Constitution says that this power belongs to A, and then the framers of the Constitution amend that and they say this power no longer belongs to A, how can it be imported that the Constitutional Convention still continues to empower convention?
That is not a convention. That is where that situation would arise if, for example, in the 62 Constitution or the interim or 73 Constitution, there were words to the contrary. All that those, as I understand it, but subject to any correction from your part, those constitutions, and including the present one, has structurally gone to the position of the Government of India Act. And therefore, the case law that has come up has come in the context of the 1973 Constitution. What I'm saying is that there's a background to that case law. It's not something that in 1979 was said for the first time. Conventions go back decades, if not centuries. That's what.
Malo, I'm grateful for your lordship's observations. Now, I will just moving on to
Mr. Salahuddin here. ये देखिए जो बुराइयां आप बता रहे हैं एनेबलिंग कंट्रीज में सब जगह हैं, क्या इन सब को रिमूव करने के लिए पार्लियामेंट ने इंटरवीन किया है, या कोई दुनिया में ऐसी मिसाल है कि प्रैक्टिस एंड प्रोसीजर ऑफ कोर्ट के हवाले से कोई लेजिस्लेशन भी हुई है कहीं?
My lord, in various jurisdictions there has been.
कोई एक किसी मुल्क का बताइए जिसमें प्रैक्टिस एंड प्रोसीजर के हवाले से कोई एनेक्टमेंट आया हो?
My lord, in various jurisdictions, for example, in the United Kingdom itself, practice and procedure of the UK Supreme Court is done by the UK by an act of Parliament.
ना उसमें बेंचेस की कंपोजिशन के हवाले से प्रोसीजर है उसमें?
My lord, it sets out divisions, etc. It gives those powers. Obviously, it gives those powers.
Mr. Salahuddin, if I may correct you, like in many cases, the American Supreme Court does not have the concept of a bench. The whole court sits. And in all important constitutional points, I think in the UK is the same situation, with the Supreme Court sitting as a whole. So I think there are 9 in America, and the UK, I think it's 9 as well.
In the UK, they do form panels, sir.
Yeah, but in only other matters, but like, for instance, that matter of Brexit, it was a full court sitting.
Yes, in both Brexits, there were full courts.
So we are really concerned with those kind of 184(3) cases, which have a larger impact, not in some sort of a...
Yes. Sir, I won't go through the other, I'll just point out the pages of my booklet. Page 94 details with the situation that happened in Nepal. Over there, when the Chief Justice started forming benches of his own, eventually not just the bars, but even the judges of the Supreme Court went on strike. Eventually, they agreed a system where both benches would be formed and cases be assigned through a lottery. Now, in Philippines...
Who decided this? Parliament? Or
no, sir. It was the Supreme Court. It was the Supreme Court. Now, in Philippines, sir, benches are formed.
साउथ एशिया में जहाँ कहीं ये प्रॉब्लम हुई है तो वहाँ पार्लियामेंट ने इंटरवीन नहीं किया, वहाँ अदालतों ने खुद ही रूल्स बना के रेक्टिफाई किया है उसको.
जी सर, but if your lordship will appreciate,
मतलब ये
this issue has been understood here since 2006 at least.
मतलब आपका
but it has not been addressed.
आप लोग भूख हड़ताल पे क्यों नहीं गए हैं? मैंने कहा आप लोग भूख हड़ताल पे क्यों नहीं गए हैं?
I'm too fond of my food, sir. सर, मैंने फिलीपींस की मिसाल दी है, पेज 76 पे है. वहाँ सिस्टम ये है कि benches are formed through a fixed criteria, 1st, 4th, 7th, 13th in seniority.
Mr. Salahuddin, we've understood your point that there is a need for that change. The question is, who brings that change? Is it Parliament or is it the court itself?
The first
Can
option,
you just address the question?
The first option was certainly for this court could have done it through administrative rules and amendment to the Supreme Court rules of 1980. And your lordship will appreciate
how the right of appeal can be conferred under the rules.
जी sir.
Right of appeal तो हो ही नहीं सकता.
Appeal is a separate issue. मगर बाकी मैं practice and procedure की.
Whereas the practice and procedure is concerned, you're right, that can be amended through the rules.
Absolutely, absolutely. Appeal has to be done separately. Now, it could have been done through this. The practice and procedure could at least have been changed by an amendment to the Supreme Court rules, but for whatever reason, it did not happen. Another way that was available to your lordships was to actually do it on the judicial side, actually examine the issue of the Chief Justice's discretion and lay down guidelines and structure that discretion, etc.
Altered the convention that is set out in the earlier case law.
Malo.
That would be on the judicial side.
Yes, and in fact, there is a petition pending before this court on this issue.
On the contrary, there are various judgments of this court which reiterate the convention that has developed by way of judicial orders. Is that true?
Yes. Although my humble submission is, sir, that when the discretion of every single other individual who acts under law or the Constitution, this court has held that it is subject to structuring and regulating that discretion, there cannot be an exception for the Chief Justice alone. Now, there is a petition that is pending before this court, CP number 15 of 2020, filed by the Islamabad Bar Association. I was appearing for the Bar Association in that case. This has been pending since 2020, and there is a specific prayer in this and the ground that this discretion of both Chief Justices, not just the Supreme Court, but also of the High Courts, it needs to be structured and regulated so as to improve public confidence.
Salahuddin, you have given two options
Yes.
to this court to resolve the issue.
Yes, sir.
What do you say about the right of appeal?
My Lord, as far as the right of appeal is concerned, I believe that it did require legislative intervention.
Legislation by
Parliament.
Two-third majority?
Sorry, my Lord.
By two-third majority? Because it's
No, sir. By a simple majority.
184(3 is a constitutional provision.
Yes, sir.
And appeal is continuation of the original jurisdiction. How this legislation can create a right of appeal against a constitutional provision originally, which is part of the Constitution?
Well, if your Lordship will allow, if you will give me 2 minutes, I'll wrap up this part and then come to that, because I have detailed submissions on legislative. Ji, sir. In any event, sir, as far it was not done on the judicial side either. It was in those circumstances that the Parliament eventually acted. Now, lastly, I'll just say this, sir, that there are 5 fundamental issues.
Ek second.
Ji.
I think you would not disagree that the Parliament legislates. Even the Constituent Assembly legislates. But the interpretation is the exclusive domain of this court.
Absolutely. Absolutely.
Constitution says that, the court says that, and the judgments say that, and it's a settled principle all over the world.
Yes, sir. No trouble.
So can the Constitution, can the legislature turn around and say, well, the interpretation of a constitutional provision that the Supreme Court has done is incorrect, and that by ordinary legislation we are going to correct it? Can it?
No, it cannot. But my submission is that this court, while asserting the mastery of the roster in the office of the Chief Justice, has not interpreted any specific provision of the Constitution. They have relied essentially on the Supreme Court rules, and those rules are subject to law, and I'll come to that.
So while there is legislation, is the Supreme Court now prevented from making rules on the subjects or the areas that have been legislated on?
Yes.
So that now the Supreme Court cannot make any rule on that?
It can make rules to further that legislation, and it can make rules on anything that is not specifically covered in that legislation, but the legislation has primacy.
So, from what you say, Mr. Salahuddin, a part of 191, and I would say the heart of 191 becomes redundant.
I would humbly differ with your Lordship.
Because
I read 191 differently.
Simple reading of the 191 essentially confers a power to frame rules on the Supreme Court and not on the Parliament or any other organ. So when you say the Supreme Court cannot, now that a statute is in place, proceed to exercise its powers under 191 and frame its own rules or extend its own rules or modify its own rules, you're essentially saying that the 191, as far as the powers of the Supreme Court is concerned, has become redundant.
No, sir. As I said, there are areas that this court still can, but the area where a law has come into force, then it is subject to that law.
Mr. Salahuddin, ये जो आपका Section 8 है इस कानून का, has that not affected an implied repeal of certain portions of the Supreme Court rules?
My Lord, I don't think it does.
As it has said, notwithstanding anything to the contrary contained, so if there is any conflict, and it specifically refers to rules, the only rules that are relevant here are the Supreme Court rules.
Yes, certainly.
So if there is any conflict, then that would be a conflict with Section 8, which would override. So there would be an implied repeal, I'm putting it politely. So there could then be an express repeal. Tomorrow an act of Parliament could be made saying section falana, the Supreme Court rules 1980 are hereby repealed. Would that be within legislative competence?
Lord, in my opinion, it is within legislative competence, but if the effect and the substance of that law is to impair in any manner the access to justice, then it's a different issue. But legislatively, they can.
They can do that.
They can. Now, my lord,
Mr. Salahuddin, please read section 2, subsection 2. Please read that of the act, which is impugned before us.
सर अगर इजाजत दें ये वाला लेग खत्म करके फिर मैं वो प्रोविजन जी मैं पढ़ लेता हूँ सर पढ़ लेता हूँ
के साथ रिलेटेड है
जी सर मैं अभी पढ़ लेता हूँ सर Section 2, subsection 2, soon after commencement of this act, the committee constituted under subsection 1 shall hold its first meeting to determine its procedure.
If, suppose, this enactment succeed, the again procedure has to be constituted by the committee.
Yes.
So the same procedure, which is the brainchild of 191, again has to be exercised by the committee. So the definition of Supreme Court, that Chief Justice and judges would not compromise.
My lord, as far as I understand the word...
You see, in the spirit of 191, the court is supposed to make the rules. But here only there are 3 persons to make rules. What do you say about this?
Ji sir, as I read section 2.2, when they talk about procedure, they are not talking about the procedure of the court. They are talking about the procedure of the committee, how it will hold meetings, how it will do that. So that power is not about the procedure of the court mentioned in 191. That is an internal arrangement of that committee to decide how often we will meet, whether it's every week or once a month or what, so on and so forth. So
But
that does not impact.
How do you determine that this is an internal matter for the Supreme Court to decide, as opposed to this is a matter which can be legislated on? As per your argument, once it is legislated upon, they have competence, they can legislate. The Supreme Court then cannot make any rule contrary to that. So they can make whatever, wherever they want to legislate, they go ahead and do so. But how does one then determine that this falls within the internal matters of the Supreme Court, hence no legislation, and this doesn't fall within the domain of the internal matters of the Supreme Court, hence you can have legislation? I mean, you just seem to be placing more conditions than you are in explaining how you're giving competence in a simple way. हर चीज को आप condition करते जा रहे हैं कि ये फिर ऐसे देखा जाएगा फिर ऐसे, तो that surely can't be the purpose and intention of the Constitution.
Mr. Salahuddin, there are 2 things. This section 3 and section 4 is actually dictating the Supreme Court. In the matters where interpretation of constitutional provision is involved, the committee shall constitute a bench comprising of not less than 5 members. It is a dictation to the Supreme Court or to the committee. Likewise, in 3, it says it shall constitute a bench of not less than 3 members. It is dictating the Supreme Court. Then, section 8. Look at the expense of section 8. Provisions of the Act shall have effect notwithstanding anything contained in any other law, rules, regulations for the timing and force or judgment of any court, including the Supreme Court. Now, where the Supreme Court has interpreted the Constitution, as I earlier said, and has set down certain rules or has interpreted the constitutional provisions, this act, 8 section act, I mean, it wipes away everything and goes on to dictate the Supreme Court as to how to conduct its business. If this is not a violation of the principle of separation of powers and interference in the independence of the judiciary, what else is?
Lord, firstly, I'll submit that Section 8 is the kind of non-obstante clause that is present in numerous statutes. Now, the thing that is to be seen, and I agree with your lordships, that if your lordships have interpreted the Constitution, Parliament cannot change that interpretation. On the other hand, there are three types of powers that this court generally exercises. One, you interpret the Constitution. On the other hand, if you interpret a mere statute, Parliament cannot override the judgment, but it can change the statute itself.
Where we have said this is a constitutional convention.
Jeez.
Which category would you bring it? Would you bring in Molasses' case and say, okay, we have changed the convention and therefore it goes?
I have humbly disagreed with the very existence of that constitutional convention. I have said that when the Parliament removed that power from the Chief Justice, there was a reasoning behind it, and there is no such constitutional convention.
Okay.
My lord.
We take your argument.
Mr. Salahuddin,
Dictation provision. When you're dictating, the Parliament is dictating the committee. It could have dictated the Chief Justice. It is now dictating 3 judges. What prevents it from dictating the Supreme Court?
My lord, with respect, I would not frame it in that leaden kind of terminology of dictating. But the court...
If you would just explain to this bench whether the Parliament is competent to legislate or not. If it is competent, then let us respect the Parliament and not view this as a dictation. It's a law then competently made. So look at this in that view. But first, let us know whether the Parliament is competent to legislate or not.
So I'll now move on to the competence.
No, I just had a related observation. At the moment we are looking at everything, nothing has happened. What may have happened, what may happen, what the pitfalls are, we are assuming those. I mean, give us this much credit that maybe whether the use dictation is used or any other word is used, may please, if the word please had preceded it, would have made a difference. The question is, this law, one way would be to let it function. And then in its functionality, you may still not be satisfied, or someone may not be satisfied and say, okay, you have not abided by the law. That question, I mean, we are assuming that we are not capable of manning this ship. The only thing is that previously there was the sole pilot, now there are 2 co-pilots, maybe in determining things go wrong, maybe that's a possibility. After all, for instance, when the Chief Justice leaves the country or falls ill, the acting Chief Justice comes in and he assumes the power. So why are we scared of our own shadows? I mean, the co-pilots, if they are there, why we are all assuming that we are leading to the iceberg which lies underneath? Nothing has happened so far. So we are actually, it's all conjecture and surmises we are based on. And the only real question comes down to is the competency. Well, that's the only real question as I see it, which Ejaz had asked the very first day. The focus on that. Either you can make the law, you can't make the law. Now what may or may not happen, and whether you call it dictation or you call it a request or you call it whatever you want to call it, better way of doing business, being more inclusive, participatory, transparent, I mean you can give it any adjective or use before that. At the end of the day, it's simply, can they make the law or not? If we even accept that this challenge lies under 184.3, just going ahead and saying, yes, okay, it lies under 184.3, just tell us that this law is constitutional, that's all.
Yes.
And whether it may not work tomorrow, and then again people will keep challenging it. I mean, people move applications under whatever, Order 26, whatever of the rule, Order 33, where the rule prescribes something to do in a particular manner, they move an application. I could not do so, please condone this. I mean, I don't know how we're going to interpret it when it comes up. So we don't want to tie our hands down how the future will be interpreted. I will come back to, Ejaz has been asking, there's only one question, is competency of making this law.
My lord, I'll move directly to competence. Now, legislative competence of the Parliament may arise in at least two ways. It may arise through reference to Article 142 and the specific entries in the legislative list, or it may arise through direct authorization by some or other provision of the Constitution. This court has recognized that. I think Mr. Bandhari had also referred to it, Province of Sindh versus MQM. That is PLD 2014, Supreme Court 532 at paragraph 62.
2014 Supreme Court?
532 at paragraph 62.
یہ دکھائیے جی. Citation 532.
Yes, sir.
2014 Supreme Court.
نام کیا ہے کیس کا؟
Province of Sindh versus MQM.
یہ ڈیلیمیٹیشن والا کیس ہے.
531 ہے.
جی سر.
لمیٹیشن.
جی سر, بالکل. اس کا ریلیونٹ پیراگراف 62 ہے سر. اور اس میں سر, I don't want to read this whole para to save time, but if your lordship sees about the third line from the bottom of the page, 577, when the main body of the Constitution provides for competent legislature, it is not necessary to look into the legislative list. And اس paragraph میں پھر کئی مثالیں دی گئی ہیں کہ کہاں ڈائریکٹ کانسٹیٹیوشنل پروویژن نے آتھرائزیشن دی تھی, کوئی کورسپونڈنگ انٹری فیڈرل لیجسلیٹو لسٹ پہ نہیں تھی. اب in my concise statement in paragraph 31, I've given about a dozen examples. I'm not going to take your lordship's time right now, but para 31 mein I've given a dozen examples where Parliament is given power to legislate on subjects which are not covered by any legislative entry.
What is the answer over here in this case?
Over here, my reliance will be 191. 191 in the cases of 2, 3, 4, 6, 7, and 175(2) in the case of Section 5.
So how do you read subject to?
Yes, I'll just come to that, but if I may first complete this.
So you're not relying on entry 55?
Entry 55 is relevant as far as 175(2) and the appellate power is concerned. I do not believe that entry 55 is relevant as far as practice and procedure are concerned.
Also not 58.
58 I will be relying upon.
You will be relying.
Yes, sir. Because my view of 58 is entry 58, and I was just going to come to that, is different from what has been expressed by your lordship. My view of 58 is that after the 57 previous entries which deal specifically with a particular subject matter have been dealt with, 58 is a catch-all kind of provision.
Does it confer legislative competence?
What it does is, sir, it recognizes, it does in the second part. In the first part, what it basically recognizes is that there will be things in the Constitution that directly authorize the Parliament. So wherever it does that, that is within its legislative competence. So that is the part which says, if I can just read, matters which under the Constitution are within the legislative competence of Majlis-e-Shura, Parliament. Now this is meant to cover, as a catch-all kind of thing, those direct constitutional provisions.
And then it is followed by 59. So
sir,
we should read 58 totally independently and not give it a restrictive meaning as 59 would indicate.
Exactly. Exactly.
If 58 wasn't there,
yes,
then we are left with 59.
Yes.
Then you are saying you could be in trouble. The law could be in trouble.
Exactly.
Otherwise, flesh it out.
Exactly. Okay. And your lordship will also see that
surely 59 relates to the other legislative entries.
Ji, sir. 59 deals with when you are covered by a specific legislative entry, it gives ancillary powers, the penumbra around it. But 58 deals with the situations where Parliament has been directly authorized by the Constitution, outside of the list. And then is there also the part that or relate to the Federation. And that is another broader catch-all kind of entry, which recognizes that there may be things that we have missed out in the earlier 57 entries. If by reading of the text of the Constitution, it is clear that a particular subject or a particular field would naturally vest in the Federation.
The number of judges in the Supreme Court is fixed by Act of Parliament or presidential order. The number of judges in the High Court is fixed by law.
Yes.
And or presidential order. Law over here would mean what? Would it relate to entry 58 or relates to the Federation?
In 193, the number of judges of the High Court?
Where it says law. Now, would it be covered by this latter part or relate to the Federation?
My Lord, I would, for the High Courts, as far as I know, there have been provincial legislation.
That's what the point I'm making. That it does certainly relate to the Federation, because under our system, under the Constitution, our Constitution, unlike say the US Constitution, we don't have separate federal court system and state court system. One unified court system applies both federal and provincial law. So insofar as high courts are concerned, in one sense it does relate to the Federation. But as soon as you say that, you remove the provinces.
My Lord,
and if you remove the provinces, well, provinces can say, well, wait a minute. I mean, high courts surely have something to do with us. So it's not that simple. You see, that's why I'm saying, that's why I was putting it to you, but I understand you disagree, that this is a negative point. You say no, it confers legislative competence. I understand your point.
My Lord, I'm grateful. Now, my submission, of course, is that Article 191 is a standalone enabling provision. Read with the first part of entry 58, it is more than enough to confer legislative competence on part of Parliament. And moreover, the Supreme Court, and I appreciate your Lordship's point about the difficulty of the High Courts, and there is, in a sense, in fact, even our provincial courts, also the CRPC, and there are numerous.
Salahuddin साहब, उसमें देखिए एक और एस्पेक्ट था कि वो ये जो 191 का इक्विवेलेंट है फॉर द हाई कोर्ट्स, वो क्या है 201 या
जी सर,
उसमें आप देखिए एक और एस्पेक्ट था, उसमें प्रैक्टिस एंड प्रोसीजर की बात हो रही है ना, हाई कोर्ट की प्रैक्टिस एंड प्रोसीजर, लेकिन देयर इन द कंकरेंट लिस्ट there were specific legislative competences with regard to procedure, civil procedure, criminal procedure. So the position of the high courts were, in the context of 201, is perhaps some different from the position of 191, where, as you have noted in your, I think, submissions or something, under 56 Constitution, 62 Constitution, there was specific legislative entry for the Supreme Court, which has been taken away.
Yes, sir.
ये एक बड़ा इसमें एक एस्पेक्ट है ना इसके अंदर कि आप देखिए कि law over there for high courts was not just any equivalent, or I don't think actually there's any equivalent to 58 in the concurrent list, but it could be related to specific legislative competences.
Well,
यहाँ पे एक बड़ा फर्क है ना, आप जरा काइंडली इस पे थोड़ा एक्सपैंड करिए। इशू इतना आसान नहीं है ये, दिस इज अ कॉम्प्लेक्स इशू व्हिच हैज मेनी ramifications.
My Lord, the other submission that I was making is that regardless of the case of the High Courts, the Supreme Court at least is undoubtedly a federal institution. It relates to the Federation, and therefore the second part of entry 58 would also come into play. Now, I've already submitted that as far as I'm concerned.
Can you repeat this point? I didn't quite get it.
Sir, matters which under the Constitution are within legislative competence of Majlis-e-Shura or relate to the Federation. So matters, as far as the Supreme Court is concerned and its practice and procedure, etc., that is obviously a matter that relates to the Federation. The Supreme Court, there might be a different view or a concurrent kind of thing as far as the High Courts are concerned, but at least as far as the Supreme Court is concerned, it is a federal institution, it relates to the Federation, therefore it is even otherwise covered by the second part of Entry 58.
How will you
The other issue about the High Courts and the Supreme Court, this problem which we are facing in the Supreme Court, the High Courts, to the best of my understanding and knowledge, and even when I was practicing law, this problem was not faced. The problem faced by litigants mostly was that my case is taking forever to be fixed. But this, I never came across this matter of which cases would suddenly pop up and there would be an urgent application, it would be granted or not granted, and all the other cases would stand in queue, wait for their turn to come up. So would it be correct in saying the High Courts are better run than the Supreme Court? I know you may as counsel not be able to say this, but I, as a Chief Justice, may pose this question that, I mean, in Bulusan, I never had this problem. No lawyer even complained or even suggested or ever wrote or application was submitted that of this nature that, you know, my case is being, for bench-specific cases are being made. I mean, there was the criminal bench, there was the constitutional bench, there was the other benches, single judges benches, the company judge, and they would rotate after once in a while. And this issue, at least I as a Chief Justice never faced, and as a lawyer, practicing lawyer mostly in the Sindh High Court, but elsewhere as well, did not come across this problem. Is there such a problem in the High Court?
My Lord, to be frank, it depends on High Court to High Court and Chief Justice to Chief Justice and the Chief Justices of this court. And that is precisely the rationale for this law, that it should not depend on Chief Justice to Chief Justice. There should be some kind of framework and structure that is.
And the only other thing which,
committee to committee.
And I would only change it, one more thing I should add. And the other reason why that problem does not exist is because there is a forum of appeal. You're not happy with a High Court appeal, HCA judgment, or an inter-court appeal judgment, or a judgment, you have a forum of appeal. So that problem does not exist. So here the problem has culminated with a number of factors. Accumulation of powers, the random exercise of power, the non-transparent manner of operating of power, the excessive use of 184(3), going into matters which are very private and individualistic or maybe not within the domain. So a combination of these factors has resulted in this act, in the making of this act, to impute some malafide to Parliament. I think that would not be fair at all, because lawyers have been in the forefront of asking for this kind of, maybe we're left with the mode and manner of who does the law. Even I haven't heard anyone from the petitioner side saying that's fundamentally wrong in this law. So all they're left with is basically, again, competency, who makes this law and who's authorized or constitutionally authorized to make this law. So the problem was created, maybe, and this is Parliament's effort to maybe resolve the problem.
Sir, agree, sir, that our grievances in respect of the High Courts are somewhat less intense because we can always knock on your doors for correction. We don't have that option available here. But just to add on to your Lordship's observation of it may vary from committee to committee, and yes, it may. But the thinking...
Surely the solution is, logically, give the power to the full court, which is where presumably it always lies when the court makes its own practice and procedure. Because you see, you started out with internal independence and all of that. With internal independence ka to logically ek hi hal hai na ji, कि भाई अगर if the court, and I'm not saying I agree with this, because with very great respect, I definitely have a serious reservation with things being imputed to retired Chief Justices. Random this, and with all due respect, sir, this is not proper. We should not impute things to those who cannot defend themselves sitting in open court. We should not do this. But anyway, let me move on. So logically the conclusion is that the matter should be placed in the hands of the full court, because otherwise there is never any internal independence. But the matter doesn't even end there, because full court always decides by majority. So logically, the minority is always in thrall of the majority of the full court. So then logically, the answer would be that the matter must always have unanimity. In other words, each and every one of us will have veto power over anything and everything relating to practice and procedure. The whole thing, with all due respect, in my view, then collapses like a house of cards. This is not the way these things happen. If there is a master of the roster, and I'm again asking you the question that to which, with a very great respect, Mr. Ibrahim did not give an answer. Who, if this law is validly enacted, who is the master of the roster? The creation of Parliament, whether it be a committee of 1, 2, 3, 4, 10, or Parliament. And if Parliament is the master of the roster for practice and procedure of the Supreme Court, where does that leave separation of powers? Where does that leave independence of judiciary? Kindly answer this question.
My submission is...
First, would you kindly finish with the competence of the Parliament? If the Parliament is competent, then the law is also competent.
So your short answer to this question, and
as I've understood, your argument is that as far as the practice and procedure is concerned, that entry 58 is to be read with Article 191, and if it is a question of power and jurisdiction, then it will be covered under entry 55. Is that correct?
Yes.
But I have a problem here. The examples you set out in your para 31